Honorable members of media and general public, secretariat team, dear viewers, ladies and gentlemen, a very good morning to you all. And it's a pleasure to welcome everyone, especially for the viewers that are watching this session. For the information, today's submission will be made available to public through the media and also on television through the Parliament channel on our OLSC platform. Kindly advising that for any sensitive information concerning this inquiry that cannot be disclosed in public, this can be provided to the committee either in writing or in private. At the outset, I request our witness and wish to remind honourable members that all questions are to be asked and addressed through the chair. This is a parliamentary inquiry and all information gathered is covered under the Parliamentary Powers and Privileges Act. In terms of the protocol of this committee hearing, kindly requesting that there be minimal use of mobile phones and that all mobile phones are to be on silent mode while the meeting is in progress. I would like to take this time to introduce our members of Justice, Law and Human Rights Committee. I'll request Honorable Dr. Salik if he can actually introduce himself.
Good morning, Honorable Chair and distinguished panel of submitters. I am Dr. Salik Ram Govind. I am a member of the Justice, Law and Human Rights Committee.
Thank you, Dr. Salik. I'll request Honorable Sharma to introduce himself, please.
Thank you, Honorable Chair. Good morning, submitters and the viewers. I am Honorable Rohit Sharma, Deputy Chairperson, Justice, Law and Human Rights Committee. Thank you.
Thank you, honourable members. Myself, I am Honourable Elbik Maraj, Chairperson on Justice, Law and Human Rights. Joining us today are the representative from University of Fiji, Acting Vice Chancellor, Dr. Saista Shamim, Mr. Joseph, Mrs. Varsha Bano, Mr. Shivet, and Ms. Kesia Tuikoro. I shall now invite our representative from University of Fiji if they can actually introduce themselves before we can actually start the session. Thank you.
Thank you very much, Chairperson, Honourable Chairperson, and Honourable members of the Select Committee. My name is Professor Shaista Shamim, and I am the Acting Vice Chancellor of the University of Fiji, as well as the Dean of the JDP School of Law, University of Fiji.
My name is Shivendranath. I am also a lecturer at the University of Fiji. I specialize in the area of criminal law, evidence, and taxation. Thank you.
Good morning, Honorable Chair and Honorable members of the committee, ladies and gentlemen. My name is Varsha Bano. I am a lecturer in law at the University of Fiji, JDP School of Law. I teach courses that include but are not limited to criminal law, process and procedure, and advocacy-related courses. Prior to becoming a lecturer in law, I have been a legal practitioner practicing criminal defense. Thank you.
Thank you. Now I give the floor to Professor Saista Shamim, if she can actually take us through the submission that they have before them. Thank you.
Thank you very much, sir. Mr. Chairman and Honourable Chairman and members of the Select Committee. We've divided our submissions in three parts. You probably have, I hope you have, written submissions as well. They were sent to the Secretariat yesterday. And so if there are any questions afterwards, you may please feel free to address us on those. What I'm going to be doing, generally speak about, give an overview and speak about the constitutional provisions that I think are very important when considering a bill of this nature, the Cybercrime Bill 2020. And one of the aspects of the proposed legislation that concerned me a little was section 17.2 of the bill, which is very broad in terms of the protection that it can provide people who have been either charged or who are about to be charged in relation to the privacy of other information or other confidential information then that can be disclosed if the warrant is applied for with respect to a court or a judge. So that is my first concern. I refer to the constitutional provisions, Section 24 in particular, privacy, but more importantly, there is a provision in the Constitution on interpretation, which is Section 7(1)(b), which says that in addition to complying with Section 3, when interpreting and applying this chapter, a court, tribunal, or other authority may, if relevant, consider international law applicable to the protection of the rights and freedoms in this chapter. And the only freedom that is and the right that is provided in the chapter, which is the Bill of Rights chapter, is the right to privacy. Now, the right to privacy also has limitations. So if there is a law that is passed limiting the right to privacy, that law has to be taken into account in a court or a tribunal or before any other authority. Unfortunately, the section that I referred to is too broad in terms of providing that protection which an individual is entitled to have when this particular provision is employed in regard to somebody who is reasonably suspected of committing a crime that would be contained within the Cybercrime Bill of 2020. The specific document that we have already attached as well to our submission is what we call the Syracuse Principles, and the Syracuse Principles come as an attachment to our submission. And I respectfully invite the honourable members to look at those principles because they're called, the full title is Syracuse Principles on the Limitations and Derogation of Provisions in the International Covenant on Civil and Political Rights. This is specifically for civil and political rights, and Cybercrime Bill immediately brings to bear civil and political rights that are also protected in the 2013 Constitution of Fiji. With respect to the limitations, essentially what the Syracuse Principles tell us, and it is a United Nations document, is that every country has a right to limit the Bill of Rights provisions, whatever they may be. So freedom of movement, freedom of expression, freedom of association, and so on, are not blanket rights. They can be limited in the case of a national emergency, for example, or a public health situation. There are a number of national security. All of those things can actually limit a particular freedom or a particular right. However, Syracuse Principles tell us that there is actually a limitation on the limitation as well. So if you're going to be limiting anyone's rights, you also at the same time have to ensure that the fundamental right itself is not undermined as a result of that limitation. So for me, as a constitutional lawyer and as a human rights lawyer, my concern is Section 17(2) of the bill, because it is very wide in respect of the power that it provides people in authority with respect. It's Section 7. Section 17(2). Yes, it is Section 17(2) of the bill, and that specifically. I'll just read it, members. Section 17(2) says admissibility of evidence. Subsection 2, the powers and procedures provided under this part are without prejudice to the operation of or powers granted under any written law when exercised lawfully by a police officer or other authorized person or any regulatory authority that by itself does not investigate or prosecute an offence. The words are without prejudice to the operation of, that is of concern, because it is ambiguous. It's not clear whether this means invokes the Constitution as well, without prejudice to the operation of or powers granted under any written law, and the Constitution is any written law. So that is the section that, for me, has actually triggered the the Bill of Rights concerns that are also provided in the Constitution. And as I said, the Constitution itself does give limitations to certain rights, to practically all of the rights. There are limitations, but one needs to interpret limitations in accordance with the Syracuse principles. So those are the issues that I have for you, honourable members, and perhaps if you would like to ask questions now, or perhaps we will do the entire presentation, because my colleagues will be looking more specifically at the other provisions of the bill. Thank you.
Thank you, Professor, for the deliberation. Okay, if you actually to change the wording of 17.2, how do you actually do it? What changes do you actually recommend to that particular clause, if there is any?
Sorry, yes. I would make it more specific. Rather than saying without prejudice to, I would say in compliance with, and refer to the specific provision in the Constitution. So, or more broadly, the Constitution itself, rather than a specific provision like Section 24, because Section 24 does provide limitation. The problem is, of course, to what extent can a limitation operate? And the Syracuse principle says that you can have limitations that would undermine the right itself, and that, in fact, in international law is not permitted. So I would be very specific, and I would say in compliance with the 2013 Constitution of Fiji, and perhaps remove the words without prejudice too, because that's ambiguous.
Okay. Thank you for that. We'll move forward. Honorable members, any questions or queries to Professor?
No, it's okay.
All good so far. We can keep on going.
Okay, we'll continue. Reps from University of Fiji, you again have the floor.
Very well, Mr. Honorable Chair. I will be focusing on the second aspect of the submission that we have drafted. If you look at the introduction, it talks briefly about what is cybercrime and what is digital evidence. A basic premise of the introduction is that cyber evidence or digital evidence is much more different from the real evidence that we deal with in the court of law. It is different from real evidence exhibits that we find in the police station, and the major premise of presenting this evidence to court depends on the authenticity of the evidence. So there are 3 points that I have highlighted in the introduction, which talks about what type of evidence is digital evidence. So it talks about degradation, talks about ownership, and it talks about original documents. This leads on to part 5 of the bill, which says on search warrants. In order to authenticate these sets of evidence, the drafters must clearly state as to what mechanisms are to be used in extracting this evidence from a computer system or from a computer data. Therefore, if you look at section 2.0 and section 16, we are humbly pleading that another section to be added, which talks about something which is in the interest of justice and in compliance with the European Convention on the Human Rights, which says they are private rights, however there are exceptions, and these exceptions only work or should be made when it is in regards to public safety, security issues, to protect fundamental freedoms of the public, etc. Therefore, the proposition is section 16, there must be another subsection which looks at how the judge or magistrate looks at in issuing warrants, and being specific as to the steps taken in terms of acquiring these data because of the digital evidence at play here. That is the first point that I would like to make, so that it is in compliance with section 24 subsection 2 of the Constitution, and it's in compliance with the European Convention on Human Rights, which says if it is to be limited, it must be with regards to public rights, public safety, etc. I'm specifically referring to the European Convention on Human Rights, which Fiji is a signatory to, and it is also stated in our constitution, so that we are in compliance with the international law and with the constitution as well, as our professor has stated. The second point, Honorable Chair, is on mobile phones and cell phones. Now, the bill is not very clear on the definition of computer devices, or what is a device. Therefore, it can be deliberated, and it is a proposal that mobile phones and cell phones are also to be included in the devices section. I have stated there what is the proposal, because mobile phones and cell phones are also used to coordinate crimes or cyber crimes. This can relate to cyber stalking, cyber bullying, crimes of cyber terrorism, identity theft, and embezzlement. The premise of using the proposition, why do we use mobile phones, is because it can be coordinated just like a computer. However, we have to tread in this area very carefully because of privacy issues. Therefore, again, it should be in compliance with the constitution, and the judge and magistrate must be able to ascertain what is the reasonable course when issuing a warrant. So basically, the two propositions are on the issuance of warrant and the steps taken whilst extracting the information from the mobile phones or cell phones, and when checking documents of a particular perpetrator in regards to public safety and security issues. That is all, Honorable Chair. Thank you.
Thank you, sir. Thank you for the deliberation. Members, any clarification? If none, we'll move forward. I believe to the third part of the submission now.
Honorable Chair and honorable members of the Select Committee, ladies and gentlemen, my submission is based on part 4 of the Cybercrime Bill, which deals with, part 3, which deals with computer-related and content-related offences. And with respect to that, we have noticed that there are two things that the current bill is lacking, and that is emphasis on the crime of hate speech online and cyber terrorism. And in my submission, I will attempt to explain why the Parliament should consider this to be a part of the Cybercrime Bill, why it is important to be implemented under this legislation. The dangers of cybercrime have always existed. It has existed for many years, and it is not uncommon for cyber criminals to attack the network system of individuals. With the COVID-19 outbreak, this is no exception to the situation. Cyber criminals constantly look for different ways to take advantage of online behavior and trends which relate to cyber attacks. At this point in time, with the increase in the percentage of the population connected to the internet and the time spent online, countries all across the globe are reporting an increase in cybercrime. Now, currently Fiji has laws that deals with content that's aimed at causing harm to a person's reputation, content that can cause harm to the computer system of an organization or a person. But these are very limited in nature. We can find them in the Crimes Act. We can find them in the Online Safety Act. They do not have a jurisdiction that extends to overseas. They do not have jurisdiction that has principles that calls for international cooperation. So we are of the view that any cybercrime bill that is to be passed by the Parliament should include the areas of hate speech online and cyber terrorism. Hate speech has been defined in our current constitution. Section 17 is important to this because Section 17 talks about freedom of speech. Now this freedom of speech, freedom of expression, freedom of publication, freedom of opinion, these are all expressed in the Constitution, but they do not advocate for hatred, or they do not they do not offer protection where such freedom constitutes incitement to cause harm. Our submission is that with hate speech, if it's expressed through an online platform, it has the potential to do more damage, because the way in which the information is disseminated, unlike controversial channels, the dissemination of hate speech online often involves multiple actors and multiple platforms, and the content is likely to stay available until discovered by law authorities. So given the protection that freedom of speech under Section 17 offers, a person should not be able to come and use the online platform to promote hate speech. They should not be able to promote offenses of a xenophobic nature and rely on this section as a blanket to cover that. So what we are saying is the law should take this section, Section 17 of the Constitution, into consideration and include those principles in the current cybercrime bill, so that those principles that recognize hate speech, that prevent attacks on the dignity of individuals, groups of individuals, or respected officers, these kind of protection is offered under the cybercrime bill. And a person should not be allowed to use freedom of expression to carry out offenses of this kind of nature, because the online platform is really big. They could do anything on the online platform. They could put up any sort of materials and rely on this particular section as a cover-up. So that's what we are submitting, that Section 17 of the Constitution, which prohibits hate speech, should be considered, and should the Parliament find appropriate, the offense of hate speech be created under the content-related and computer-related offenses of the cybercrime bill. My second point is in relation to cyber terrorism. This is another offense that we submit the Parliament may look at and consider including in the current cybercrime bill. Cyber terrorism is a very complex area. However, if you really analyze cyber terrorism and you get down to understanding how it operates, you will realize that cyber terror against a country and its citizens can take place at a number of levels of sophistication. The simplest level of cyber terrorism attacks are the kind that deny service and disrupt the daily life with no substantial, irreversible, or lasting damage, whilst the highest level on the scale would be an attack on the organization's core operational and operating systems. Now, cyber criminals may attack certain crucial computer networks, which possibly cause the disruption of essential public services, such as water, power, hospital systems, financial systems, and emergency services. The modern cyber terrorist may be able to do more damage through the use of a keyboard than that with a bomb. So these kind of attacks cause a havoc on the infrastructural information and computer networks. It also brings devastation to nations' economy, security, and public welfare in the physical world. Countries such as United States of America, India, Pakistan, they have all experienced this, and they are now tirelessly working towards implementing laws that protect them from an offense of cyber terrorism. And I have in my submission what the law would look like, a draft, what the law would look like if the elements of the offense, what it would look like if it were to be implemented under this particular cybercrime bill. So with respect to the point on cyber terrorism, we cannot underestimate the threat that it poses to our infrastructure. So we understand that Fiji has been working towards ensuring a safer cybercrime for all. the draft cybercrime bill is here, and it will take us a step further towards achieving this objective. We are humbly submitting to the Parliament on this point to consider incorporating laws that deal with cyber terrorism, as the presence of the stringent laws that deal with these kind of offences will not only act as a deterrence, but it will also enable us to protect our country and its people when the need arises. So given the COVID-19 situation and the trend whereby people are moving online now, everything is done online, we have to prepare ourselves, and we have to, whether we feel that we are facing the threat significantly or not, regardless of that, we need to have that in the legislation so that in the future, if we are faced with this threat, we are prepared. That is the end of my submission, Honorable Chair. Thank you for listening.
Thank you, Ms. Bano, for that comprehensive deliberation with regards to the cybercrime bill. I believe all three sections that you people have actually mentioned, we have taken note of it, and we shall be actually discussing it once we actually do sit in the committee stage for deliberation of all the submissions. Any final words from the submittees?
Just one point, Honorable Chair. In terms of the European Convention on Human Rights, our constitution is actually mirroring whatever is in the European Convention on Human Rights, and international law is looked into when deciding cases in the court of law. Therefore, the proposition is with regards to that, and specifically with regards to 24 subsection 2, which states if we are to limit or exercise our judicial state discretion in against private rights, it must be done very carefully and in accordance with the Constitution and international law. Therefore, that is our submission, and that is the basis of the search warrant and even cyber stalking and cyberbullying because of the issues of privacy at stake. So therefore, a balancing act has to be done between public rights and private rights, and that is what is the crux of the submission. That is your Honorable Chair. Thank you.
Thank you, sir. I'll open the floor now. If my members they have any questions or clarification they want to seek from a representative of University of Fiji, please you can go ahead and do so. Honorable Govind.
Yeah, thank you, Honorable Chair. I'd like to thank the presenters for a very comprehensive presentation with a lot of new things which we did not know. I think we'll deliberate on those and try to incorporate into our submission at the committee level. So at this stage, I don't have any further questions, but if we do, then we'll write to Professor Samim and seek clarification. So once again, thank you for your input into this very important bill.
Thank you very much, sir. Just as a final word, if I can just ask the honourable members to look at the Syracuse Principles, because it's very easy, since it's the United Nations document already, it's very easy to take care of all the issues that we've spoken about with respect to constitutional protections, and include that as a reference as well. So if you would like to be further informed of the limitations clauses, because it's relevant not only for this type of legislation, which is to combat a particular crime, which everyone agrees ought to be combated for the reasons that we have said, but also in relation to any other proposed bill that may come before the Select Committee on Justice and Human Rights, with respect to paying heed to the constitutional provisions which protect rights, but at the same time provide limitations which allow government or the state to put in place certain legislation to limit those rights. But as I said before, to reiterate, the limitations themselves have limitations in international law. So thank you for the opportunity to talk about them.
Thank you, Professor. Honorable Sharma, any final comments?
Thank you, Honorable Chair. I would like to thank the presenters this morning for their submission. It was a detailed submission, and definitely we will come back on this when we will meet in the committee, and if we will have further queries on this or some other details we will need to know, definitely we will come back to them. But so far, it's thank you. No other comment.
Thank you.
Thank you, Professor. On behalf of the committee, I'd like to actually thank the representative of University of Fiji. I believe this is our fifth bill that we are scrutinizing, and this is the first time we are having a submission from University of Fiji. But I would like to actually show my appreciation, though it's a bit a late start, but still it's a start, and we would actually like to see more of you guys actually in coming bills that are actually presented to the committee. This kind of discussion are very fruitful, not just for the committee, but for the general public, because at the end of the day, it's the general public who's going to be affected by any laws that are actually put in place by the Fijian Parliament. Once again, thank you very much and hope to see you in the near future.
Thank you.
Vinaka.